My little brothers and sisters, this is Advocate P. Devmorari talking to you from Ahmedabad city, Gujarat state, India, that is our Bharat. Before I talk about my video, let us congratulate each other for celebrating our 78th Independence Day on 15th August 2024. Today I selected a very good topic from Limitation Act. It is useful for everybody. The Limitation Act 1963, Section 5. I'll read out Section 5, what it says. Any appeal or an application other than an application under any of the provisions of Order 21 of the Code of Civil Procedure 1908 may be admitted after the prescribed period if the appellant or applicant satisfies the court that he has sufficient cause for not preferring the appeal or making the application within such period. So in this sufficient cause is to be shown. Suppose limitation period is for 3 years, and due to some circumstances after 10 years, 7 years or 12 years even, you are filing your civil suit, then you have to show the sufficient cause to the learned court. Then only your appeal will be admitted, otherwise not. Now what do we mean by sufficient cause? These are only 2 words, sufficient cause, but it signifies so many things. What constitutes sufficient cause cannot be laid down by hard and fast rules. The expression sufficient cause is not defined, but it must mean a cause which is beyond the control of the party, invoking the aid of the section. It also includes absence of inaction for want of bona fides or negligence. Parties seeking condemnation must place before court facts constituting sufficient cause. No presumption can be made if party fails to place sufficient facts before the court. The question of the existence of sufficient cause is one to be decided from facts and circumstances of the particular case. There is no presumption that delay is always deliberate. Court will not make such presumption. Bona fide and sufficient cause are conditions precedent to the condemnation of delay. Nothing can be considered to be bona fide which is not done with care and attention. The explanation offered should be reasonable, proper, and acceptable. Sufficient cause means the party has not acted in a negligent manner, as there is want of bona fide on its part in view of the facts and circumstances of the case, or party cannot be alleged to have been not acting diligently or remaining inactive. It is better, while giving explanation of filing separate application for the delay, condemnation of delay, file affidavit. That will carry the weight. Expression sufficient cause means sufficient cause and not a mere narration of facts, that too however. It should be genuine. The word sufficient cause should be liberally construed so as to advance substantial justice when no negligence or any inaction or want of bona fides is imputable to a party. The application for condemnation of delay containing substantially all the relevant material and is supported by affidavit, then sufficient cause has been shown for condemnation. When the delay in filing the petition was explained by filing affidavit, which was not controverted by the opposition party by filing any counter affidavit, the petition cannot be rejected on ground of delay. Grounds for condemnation of delay are required to be spelled out clearly and distinctly in application for condemnation of delay. Courts generally follow liberal approach, particularly when no negligence, inaction or malafide can be imputed to party. Any reasonable cause which prevented a person from approaching the court is said to be sufficient cause. Two things are required to be shown: that there was cause for delayed filing appeal or application, and cause was sufficient. The concepts such as liberal approach, justice-oriented approach, substantial justice cannot be employed to jettison the substantial law of limitation, especially in cases where the court concludes that there is no justification for delay. If there is no justification for delay, please don't argue for a liberal approach or justice-oriented approach or substantial justice. Highly pedantic approach should be eschewed, and an approach which furthers the cause of substantial justice should be adopted, and parties should be allowed to prosecute its remedy on merits rather than being thrown out on technicalities. Expression sufficient cause should be considered with pragmatism and with justice-oriented approach rather than hyper-technical approach. The approach in considering whether sufficient cause for delay exists should be pragmatic and not pedantic. But the interests of ultimate justice should be shifted by fine technicalities. At the same time, erroneous delay in seeking legal redressal cannot be ignored unless there are sufficient reasons. Refusing to condone delay can result in meritorious matter being thrown out at a very threshold and cause of justice being defeated. When sufficient cause is shown, delay at a stage should normally be condoned. Reason? At appellate stage, it is not a question of jurisdiction, but a miscation of law and fact. The test of sufficient cause is purely an individualistic test and not an objective test. That is why no two cases can be treated alike. The categories of sufficient cause are never exhausted, and each case spells out unique experiences to be dealt with by the court as such. Now, there are some guidelines to determine whether sufficient cause exists or not. Number one, litigant does not stand benefited. Number two, refusal to condone may be heard a meritorious matter getting thrown out. Number three, evidence delay. Pedantic approach should be avoided. Fourth, substantial justice is to be preferred against technical flaws. Number five, there is no presumption that delay is always deliberate. There should have a presumption. Six, injustice is to be removed. When order refusing to condone delay is arbitrary and illegal, it is liable to be set aside. These guidelines are given as a source of information 1991 in bracket 2, all LJ 1273. The question of the content or extent of delay has no direct nexus in law with the sufficiency of cause to condone it, and these two are diverse and independent factors. Now I'll give you some points for condonation of delay, when delay can be condoned. It is not yet exhausted, list goes on, but I'll cite a few points. Number one, illness and the old age of applicant resulting in communication gap can be said to be sufficient cause for condonation of delay. These points are showing sufficient cause. When can you say that we have shown sufficient cause? Number 2, period spent in wrong forum would constitute a sufficient cause and can form valid basis for condoning the delay under Section 5, subject to the satisfaction of the court. Number 3, not knowing the delay fixed for hearing because of non-service of notice, therefore delay can be condoned. Non-appearance of counsel to whom case was entrusted by counsel for plaintiff who had gone abroad, stop appearing after 2 hearings, then you can say that is sufficient cause. Number 5, having no knowledge of the approved order, that will be sufficient cause for condemnation of delay. Number 6, absence of opposite party cannot be sufficient cause. You have to prove your sufficient cause. 7, wrong procedure followed by mistaken legal advice. No latchings on party, held it was sufficient cause. 8, court will not apply beneficial provisions like Section 5 and 14 in a pending matter. Once sufficient cause is found, then the length of delay may not be an impediment in condoning delay. Sufficient cause તમે બતાવો પછી કેટલા વર્ષનો delay છે કોર્ટને સુધી. Number of days, delay is not deciding factor in considering the application for condemnation of delay in filing an appeal. The deciding factor would be as to whether there is possible or reasonable explanation for delay in filing appeal, and say plausible or reasonable delay will be sufficient cause contemplated in Section 5 Limitation Act. Under Section 5, it is for the applicant or appellant to satisfy the court that he has sufficient cause under Section 473 Old CRPC. The court is to be satisfied on the facts and circumstances of the cause that the delay has been properly explained. This is a criminal matter. Law of limitation cannot be applied so liberally that it renders a vested right in another party ineffective. Delay should not be condoned if by delayed filing of the appeal there was some gain on the benefit, just for the gain of any party. Learned court will not condone the delay. Sufficient cause must be cause which is beyond control of party and should be bona fide. If you are genuine, if you are right, then court will condone your delay. Condone means maaf karse, and your appeal will be admitted and will be heard by the court. Well, hope you have got some good information. If you like this video, please subscribe, like it and share it. Sharing is very important because everybody doesn't know the law. And this is the purpose of educating the people. Hope you have enjoyed this video. We'll see you in the next video. Thank you, thank you, thank you. Jai Shri Krishna.